Very good morning, my dear friends. We are almost in the last chapter under our slot, which is liquidation of companies. So almost we spent till now 5 sessions. I think so, if I'm not wrong, which is 6 sessions. Sorry. In such 6 sessions, we completed a couple of chapters like amalgamation and internal reconstruction. The code related content and notes and all such stuff was I already uploaded. I know some of the students may face the technical issues in downloading such notes, but no worries. At the end of my sessions, I will definitely provide with that. And I also seen certain mails which regarding the material only. Intentionally, I didn't reply to anything because just I want to provide the whole material once again at the end of my sessions. Okay. Okay, right. Come back to this chapter, liquidation of companies. First of all, almost an hour, we are going to spend good time on intro part of the liquidation of companies. Once you can aware, once you will have a good feel that, sir, once we know what really liquidation means, or in the process of liquidation, what really going to occur, then we can focus on the problematic issues. Okay, that is the background theme regarding the liquidation of companies. And one more thing, guys, most of the times the chapter weightage is they are giving like sometimes 5 marks problems, sometimes they might give for 8 mark problems. And one concept is that which is liquidator final statement, or either from statement of affairs if the question comes, and the question depending upon the time taken to resolve that question, they may ask such question for 12 marks as well. Okay, but there is no relevance to ask such questions for 15 marks because these questions are not that much of lengthy as like in case of amalgamation and internal reconstruction. Okay, fine. Now let me open my OneNote related to liquidation of companies. Guys, hope you all are with me, and please participate your answers in the query box as well. Just a moment, guys. I'll also open my query box. Just a moment. I already opened, but which was not updated. Just a second. Yeah, fine. Now, can you please tell me, guys, all of you, is there any difference between the concept of liquidation and the concept of winding up? Can you please tell me? All of you, please participate with your answers in the query box. Quickly, guys. Is there any difference in between liquidation and winding up? Both are same. Or synonymously people are using. Or conceptually, is there any difference? Tell me, guys. Sir, to understand these two words in the better manner, I will tell you what exactly the liquidation is all about. For example, in a company, if such company is decided to liquidate, you know, liquidation is nothing but closure of the business. If it is the partnership firm, people are in general using the word dissolution. If it is in case of the company, which they are using the word liquidation. Am I right? When a company decided to liquidate, if a company decided to liquidate, then what it will do, you know, they will appoint liquidator. Sir, who will appoint liquidator? And such all issues we will discuss at later point of time. In very layman approach, a liquidator will be appointed. What are the duties of such liquidator? You know, from the date of liquidation, the cutoff date of liquidation, he will start realizing all the assets. He will start realizing all the assets, as well as he will start making payment to various liability holders as well. That means realization of assets and discharging of various liabilities. Discharging of various liabilities is the main task made by the liquidator. Do you agree, all of you? And practically, I am telling you guys, for realization of assets and discharging of various liabilities, do you think that liquidator he may complete within a month or within a week? No. Such process in generally will take place for a number of years as well. Sir, we are not talking about a sole proprietor, or we are not talking about a small partnership firm, which are joint stock companies. Just you can imagine the Reliance Industries Limited, what size it is. You can imagine TCS. Okay, what is the net worth of Wipro? All such companies are having big net worths and big turnovers. You can imagine the Indian Railways. Okay, what are the different assets, where it was scattered, identification. So who are all the various liability holders? What are the different parties available? For such thing itself, liquidator approximately will take a minimum 1 to 2 years, guys. Because liquidator is completely an outside person. And that too, realization means selling of such assets into the outside market. That is also uh, not a process. It in generally will be completed within 1 or 2 days. Because in our organization, certain assets may not have a high liquidity. For example, in our organization, if we have a stock, it have good liquidity. But in the same organization, if you have a building, well, compared with stock, building doesn't have a speedy recovery to liquidate or speedy recovery to realize. Am I right or wrong, guys? So that is the reason why this process of liquidation generally takes place much time. Okay, we understand that point, sir. Apart from this, during this time period, liquidator will also continue the business activities as well. That point also you should need to remember. So that means once the company decided to liquidate, the entire shutdown is going to happen, sir? No, the manufacturing process is still going on. The operations are still going on. We are paying salaries. We need to pay the electricity bills. Do you understand? Slowly, we will cut down each and everything once day by day passing. Do you understand? Sir, this entire whole concept is known as liquidation. Once after settling all such issues by the liquidator, liquidator will submit his final copy to the court of law. Has submitted his final copy in the court of law. Then the court will pass an order which is known as winding up order. Even though people synonymously use the words liquidation and winding up, both are same. Conceptually, liquidation is different from winding up, because liquidation is the procedure to be adopted by the liquidator to get the winding up order. Do you agree? Liquidation is the procedure adopted by the liquidator ultimately to get the winding up order. What is the meaning of winding up? Winding up is a event. It is not a procedure, which is an event, which is ultimately occurred due to the procedure adopted by the liquidator. And that too, once in the court of law or the court will pass the winding up order, then ROC will struck off such company from the company's database. Once a winding up order is passed by the court, then ROC means register of companies. So entire companies are administered by the ROC, right? Register of companies. Each and every state contains the ROC. If it is Telangana, ROC Hyderabad. If it is Karnataka, ROC Bangalore. If it is Delhi, ROC Delhi. Like that, each and every state, it have their own jurisdiction of ROC. Then, based upon the registration of that particular company, once the court of law order the winding up order, then particular ROC will struck off such company name from the database of the companies. From that particular date, nowhere that company presence will be there. And after the winding up order, no party can file a suit on the company. And a company cannot file any suit on the other party as well. So the legal entity comes to an end once the winding up order passed by the court of law. So that's why literally there is a difference between liquidation and winding up. But for throughout the chapter, synonymously we are using the words liquidation and winding up. We are replacing with each other because both are ultimately representing the process of closure of the company. So that's why we are using the synonymous words. Now hope you understand the conceptual difference as well. Okay, just a second, guys. Please, all of you be hold for 1 minute or less than a minute. A small technical issue is going from my side. Just a second. Yeah, fine. Thank you, guys. Everything is settled right now from my side. Yes, come back. Come back to the material here. So if you observe here, meaning of liquidation. Liquidation is the legal procedure, which is the legal procedure by which company comes to an end. That means which is a procedure. I clearly told you. Winding up, as per section 2, subsection 94A of the Companies Act 2013, winding up means winding up under this act or the liquidation under the Insolvency and Bankruptcy Code 2016 as applicable. Okay, what is this code, sir? We know the Companies Act 2013. What is this Insolvency and Bankruptcy Code 2016 and all about? Now I'm going to discuss. Okay, so just here they are giving the literal definitions, but the conceptual difference I already explained through my OneNote. Now come down, all of you. Sir, you know, company is an artificial person which comes its existence through jurisdiction authority given by the Companies Act 2013. Am I right? But to close that company, the powers are not only in the hands of the Companies Act 2013, the powers are also in the hands of another statute, which was Insolvency and Bankruptcy Code 2016. Now, the liquidation procedure or the winding up, any words you can use, either liquidation or winding up. Companies Act 2013 as well as Insolvency and Bankruptcy Code 2016. We can simply call it as IBC or IB Code, Insolvency and Bankruptcy Code 2016. You may have a doubt that, sir, we are talking about companies. Why we are involving another statute into the picture? The reason is IB Code 2016 will not applicable in all cases. IB Code 2016 applicable whenever the compulsory winding up happened due to inability to pay debts by the company, or the company can go for the liquidation in the voluntary situations. So to understand this entire story in the better manner, let me start discussing the things through a a small diagrammatic representation. Please consider it, all of you. So we are talking about the liquidation procedure. When Companies Act 2013 will be applicable, when IB Code 2016 will be applicable, I'm explaining. So the winding up is basically of two types, that is compulsory winding up. You know, compulsory winding up means company is not willing to close the business, but someone or due to activities done by the company, it should need to close the company. That is mandatory winding up. Another one is voluntary winding up. Sir, voluntary winding up means nobody is telling to close that company, but as per the voluntary actions of the company, either shareholders or the creditors or any other party, just they want to close their business activities. Now, in case of compulsory winding up, is that company is need to close their business activities due to inability to pay debts. Yes, that is the case. Simply the company is become insolvent. Inability to pay debts means if you realize all the assets, then the proceeds through realization of assets are not sufficient to make repayment to all such liability holders. Then we can call it as inability to pay debts, or then we can call it as insolvent. If the company become insolvent, then Companies Act 2013 doesn't applicable. That is the liquidation procedure entirely decided by whom? Insolvency and Bankruptcy Code 2016. No, sir. The company should need to close their business activities compulsorily, but not due to inability to pay debts. Due to various other reasons. Means, or for the timing, let me put the other reasons. The reasons I will tell you at later point of time. Due to other reasons. That is other than inability to pay debts. Sir, can you please elaborate what are such other reasons? Just be hold, I'll explain. Then Companies Act 2013 provisions are applicable to close the business of such company, or the entire liquidation procedure is going to be adopted based on Companies Act 2013. Similar way, in case of voluntary winding up to 31st March 2017, the entire voluntary winding up procedure was monitored by Companies Act 2013. Our Companies Act 2013 provisions clearly decide the liquidation procedure. But after 31st March 2017, again, IB Code 2016 coming into the picture. Now, you may have a doubt that, sir, why Insolvency and Bankruptcy Code 2016 coming into the picture to close the company affairs? So the provisions of Companies Act 2013 are not enough to deal the liquidation procedures in certain special circumstances. The reason is a lot of fraudulent activities were occurred earlier. If the provisions of Companies Act 2013 were followed, then a lot of fraudulent activities were occurred and the company unable to provide justice to the various parties. And that too, you know, the liquidation procedure will take number of years. If the administration activity which related to the liquidation, if it will also supervised by the Companies Act 2013, then all the other administrative activities will going into the side track. That means, sir, each and every company should need to prepare their financials. Then after that, it should be audited by the auditor, the financials, and along with the audit report, after that, they should need to conduct a general meeting. And after clubbing all such things, annual report, they should need to upload in the form of ROC filings. So then in the ROC filings, if any mistakes or some errors or something will be there, again, the ROCs will be come back to the companies. So such all procedures and all other administrative activities in generally done by the ROCs as per the Companies Act 2013. So they are already end up with so many activities. That's why the central government feels that it is better to put some of the liquidation procedures, so which are having the serious issues, we can just assign the duty to a separate body at that particular point of time. They are formed an act which was Insolvency and Bankruptcy Code 2016 Act, which came into effect with effective from 1/4/2017. If you want, I'll open that. Just a moment, please. So come here. Insolvency and a Bankruptcy Board. I'm opening this. Okay. This is the official site, IBBI, which is known as Insolvency and Bankruptcy Board of India, IBBI. Okay. So if you check here about IBBI, just I'm opening. What about the IBBI is the Insolvency and Bankruptcy Board of India was established on 1st October 2016 under the IBC Code 2016. It is a key pillar of the ecosystem responsible for implementation of the code that consolidates and amends the laws relating to the organization and insolvency resolution of a corporate persons. That means companies, and not only companies, the authority will also extend it to other than companies as well. If you check partnership firm and individuals and etc. That means the main objective of introduction of this code is to provide justice for all the persons and to avoid the frauds internally occurred in the organizations. It is an unique regulator. Yes, this word gives the entire meaning of IBBI, guys. Regulator means, what is the meaning of regulator? It will regulate everything. It will regulate to stop frauding. It will regulate to occur the activities to complete the activities in the justifiable manner. Regulates a profession as well. Process. It has a regulatory oversight over the insolvency professionals. So who are such insolvency professionals, sir? Just now I talk about liquidator, right? Sir, once for that particular company, the liquidation procedure is adopted, or the liquidation procedure need to be adopted as per IBC Code 2016, the liquidator will also going to be adopted by IBBI only. As per the IBBI, certain professionals they may appointed, which are known as liquidators. They will conduct an examination. If you check here, examination is also there. Check here, examination, limited insolvency examination. The persons who actually wrote the exams under such a limited insolvency examination, they can be act as a insolvency professionals. In the layman approach, we can talk it as a liquidator. So they have the regulatory power, regulatory oversight power over such insolvency professionals and insolvency professional agencies, insolvency professional entities, and information utilities. Okay, hope you have some clarity right now. So a separate body which was IBBI was established by Indian government to get the good regulatory insight over the insolvency professionals, over the corporates, over the partnership firms, over the sole proprietors as well. And one more thing, guys, here I'm telling you, a chartered accountants can also act as a insolvency professionals. Yes, our chartered accountants can also act as a insolvency professionals. Okay, provided we need to qualify certain examinations, we are also qualified persons, because except as who knows much more about the financial particulars of a particular body. Okay, that is the reason why they are always provide a red carpet to us. So definitely we are the eligible persons for such insolvency to acting as an insolvency professionals as well. Come back. So just I'm deviating from the subject just to get the better clarity. Here I introduced the Insolvency Bankruptcy Board of India as well. Now coming to the picture, sir, due to inability to pay debts, IBC Code 2016 provisions are applicable. Due to other reasons, Companies Act 2013 is applicable. And in case of voluntary winding up, up to 31st March 2017 means the scenario right now not takes place. So earlier, which was Companies Act 2013, right now the entire voluntary proceedings are as per IB Code 2016. Do you agree, all of you? Sir, now here I told you some other reasons, right? Sir, in which situations Companies Act 2013 provisions are applicable in case of compulsory winding up, sir? That is, other than inability to pay debts, what are such situations, sir? Let me explain such situations through my notes, guys. Just a moment. Situations in which NCLT may order for compulsory winding up. That means Companies Act 2013 is applicable due to other reasons. The order will be made by whom? NCLT, National Company Law Tribunal. I already told you, regulator as per the Companies Act 2013 are ROCs and NCLT and NCLAT, National Company Law Appellate Tribunal, which was previously known as Company Law Board. Those were changed it as a NCLT and NCLAT depending upon their jurisdiction, okay, or depending upon their powers. Fine, come down. So that means the NCLT may order for the compulsory winding up. In which situation, sir? First of all, you should need to understand one thing here. To make an order for compulsory winding up, somebody should make a petition to the NCLT. Or certain times the NCLT may also take the suo motu actions to pass an order for the compulsory winding up. Both are possible. Somebody will make a petition means maybe ROC will make a petition to the NCLT sometimes, or the central government may also make a petition to the NCLT, or maybe the representative of the central government may also make a petition to the NCLT. Sometimes the shareholders will make a petition to the NCLT, or sometimes the creditors also can make a petition to the NCLT. So who actually made the petition, that doesn't matter. If petition comes, then after checking the entire affairs of that case, then NCLT may pass an order of compulsory winding up. Or certain times the NCLT have a suo motu powers also to pass an order for the compulsory winding up. First of all, we will discuss what are such reasons. The company affairs are against the sovereignty and integrity of the whole country. How it will happen? Just for example, if India declares war against a specific country, okay, let us assume there are certain war situations occurred in between India and China. So which was recently also happened. That's why I'm taking the same examples. For example, a company so-called as X Limited is in the process of manufacturing of weapons. They took the license from the central government and everything which is legal only. There is an agreement in between China and X Limited that X Limited should need to supply such weapons to the China. Now, during the war situation, if X Limited supplies such weapons to the China, which is against the sovereignty and integrity of the country, then at that particular point of time, to protect the interest of the entire Indian citizens, then the NCLT may order for the compulsory winding up. Do you understand? So like that, if such activities are against the sovereignty and integrity of the country, then the NCLT may order for compulsory winding up. Next, second one. The company affairs are fraudulent manner, or the company was established to deceive the public. They are taking funds from the public by issuing the shares, which is a listed company, which is a public limited company. So that's why they are issuing the shares. They collected money from the public. And what their intention is all about, just the company is a dummy company. They are really not conducting any business activities, or they are conducting some business activities. With that, just they want to deceive the public. If that is their intention, then if either ROC or the representative of the central government will check such situation, and based upon that will make a petition to the NCLT, then NCLT may order for compulsory winding up. Next, if the company defaulted filing their annual returns and financial statements continuously for a period of 5 years. Sir, what about this annual returns and financial statements? So to understand that thing in better manner, so first let me explain the dark side of the company situation. Why I am calling it as a dark side. In generally, such side will not be known to the general public other than the financial professionals. Sir, dark side means what happened, uh, the companies, they are conducting their business activities in generally for a 12 months. You know that after conducting of the business activities, they might prepare the financial statements for the date 31st March of so and so year. That is also not possible to prepare the financial statements as on that particular date. They might prepare the financials after the closure of the financial year in generally. Am I right? Fine. So after that, once the financial statements are ready, that is after certain number of months, that is after 1 month or maybe 15 days, depending upon the size of the company. Once the financial statements are ready, such financial statements are ultimately approved by whom? Such financial statements are approved by board of directors. The reason is, it is the responsibility of the management to prepare the financial statements. It is the responsibility of the management. If any fraud or errors occurred in such financial statements, they are responsible. So certain responsibilities are given by the Companies Act 2013. That's why they are ultimately approved by the board of directors. Once those are approved by the board of directors, such financial statements will go to auditor. Actually, auditor will start is conducting his audit activities before that as well. But auditor should need to give his audit report after the financial statements are approved by board of directors only. Then auditor will issue audit report. Fine. Once the financial statements are approved by the auditor, then such financial statements are known as audited financial statements. Financial statement plus audit report is an enclosure. Then the company secretary, or in generally the persons who are into the affairs of the company, administrative activities, will provide a notice to the shareholders. He will send a notice to the shareholders. Along with this notice itself, they are also attaching annual report. Annual report means it contains the financial statements, it contains the audit report. Apart from such all things, what are the significant decisions taken by the board of directors, and things need to be discussed in the general meeting through an explanatory statements. And at the last page, they're also sending an invitation to the general meeting. Such all they are putting as a bunch, which is known as annual report. Through that annual report, along with that notice, they are sending to the shareholders, which is, you can also take it as an invitation for the general meeting. Then the company may conduct the general meeting. In such general meeting, they took certain proper decisions, and here certain general business activities they may discuss, or special business activities also they may discuss. General business activities means these are compulsory each and every year, which is also known as AGM, annual general meeting, where appointment of auditor, where the appointment of next board of directors, then declaration of dividend, then laying of books of accounts. All such 4 activities are known as general business. Apart from that, any other activity they are going to discuss, which is known as special business. After completion of general meeting, what will happen, once the general meeting completed, within 30 days, they should need to submit AOC 4. I think so, within 30 days, exactly, right? Yeah, exactly. AOC 4 contains financial statements. How the ROC will know the financial statements of a particular company? How the ROC will know whether the provisions of Companies Act 2013 were exactly followed by whether the company or not, or is there any violation or the deviation from the provisions? Once the company will upload a specific form of return in the MCA website, then only ROC can realize such facts, right? So that's why in the form of AOC 4, which contains the financial statements and the date of annual general meeting, and who is the actual auditor, and what is the board they are going to appoint in the future, such all issues they might included in such financial statements. Within the conclusion of the AGM, within 30 days, they should need to file this form, which is known as one form of the annual return, which is AOC 4. And another form also they should need to upload within 2 months, I think so, which is 60 days. within 60 days, they need to upload, MGT 7A for a 1% company or a small company. Other than that, MGT 7. For small company or 1%, they need to upload MGT 7A. If it is other than small and 1% company, they need to upload MGT 7. So MGT 7A or MGT 7 is prescribed to upload certain details related to shareholders, who are all the different shareholders, and regarding their contributions, and regarding the charges, certain other information other than the financial statements related to the company. They should need to upload. AOC 4 and MGT 7A or 7 put together, we are in generally call it as annual returns. So in the audit firms, which are known as ROC filings. Do you understand what I'm telling? Now he is discussing about that point. The companies defaulted filing their annual returns and financial statements continuously for a period of 5 years. Then the NCLT may order for compulsory winding up. Do you understand what he is telling here? Next, sir, one more situation. And the NCLT sumoto decide that on equitable basis, it is just the equitable basis to close the company rather than continuing the company. Then in sumoto basis, NCLT may order for compulsory winding up. And the company can also pass a special resolution and make a petition to the NCLT. Then the NCLT also, also based on their discretionary powers, if it is justifiable, they can just close the company. So in these situations, the first 3 situations are important. In the first 3 situations and the next 2 situations, NCLT may order for compulsory winding up. Once the company is going to close their business activities based on the order made by the NCLT, then provisions of Companies Act 2013 are applicable. Hope you understand the situations as well. Okay, sir, in this chapter, even though Insolvency and Bankruptcy Code 2016 rules are applicable, the liquidation procedure under that act is different from liquidation procedure under Companies Act 2013. Even though the procedure is altogether different, we are completely discussing this chapter in accounting perspective. That's why whether the liquidation is going to happening through Companies Act 2013 or it is going to happen through IBC code, it doesn't differentiate with respect to the accounting treatment. Do you understand? But the legal procedures and the legal system and the authority who appoints and the procedure what they need to adopt altogether different from IBC code to the Companies Act 2013. Hope you understand that point. Next, one more thing, guys. What the legal system in generally occurred in case of voluntary winding up, also I'm going to discuss with the help of IBC rules and regulations. Just it is also a legal procedure which is also doesn't have any relation with the accounting perspective. You can straight away simply assume that whether the liquidation is going to occur through IBC code or the Companies Act 2013, the procedure will be same. For our problematic approach, you no need to check whether the liquidation occurred based on IBC or whether the liquidation occurred based on the Companies Act 2013. Do you understand what I'm telling? But before checking all such issues, please let me allow to discuss how the IBC voluntary rules will be in generally administered when the company decide to liquidate voluntarily. Is it okay, guys? Come down, all of you. Which are IBC code 2016 voluntary regulations I am discussing. Just a second before that. Guys, hope you all are with me, right? I'm not checking my query box. Just put your thumbnails quickly. Thumbs ups if you are with me. Before proceeding, IBC code 2016 voluntary regulations. Please, all of you, let me know, guys. Nobody is responding. Yes, MGT 7 is annual return. You are correct, my dear. Fine. Good. With you, sir. Fine. You are rocking law also, sir. Accounts is also form part of law only here. Accounting is nothing but which is based upon the particular statute only, right? Which may be an accounting standard, which may be a statute, that is Companies Act 2013. Without knowing the law, how we can proceed with the accounting issues, right? Fine. Come back, guys. IBC Code 2016 Voluntary Regulations. Now, just you need to understand before discussing such voluntary regulations, one thing. Sir, in case of voluntary winding up, the company is going to liquidate due to inability to pay debts, other than inability to pay debts. If a company decided to winding up voluntarily, means the company financial position is good. The company is solvency position is good. It was not insolvent. It is solvent only. Then at that particular point of time, only voluntary winding up is possible, right? To prove that, sir, my company is a solvent, that's why only we are going for voluntary winding up. To prove that, board of directors should provide certain information. The same point actually he is discussing here in the first instance. Majority of the directors, sir, why this responsibility is within the hands of directors, sir? Sir, except the persons, directors, who will know about the company's affairs accurately. Persons who are conducting the business activities only know the accurate information. That's why majority of the directors will provide a declaration. And such declaration should be in the form of affidavit. Affidavit means that lawyer or particular lawyer signature should also be required there. And the director should also put their signatures, and the stamp duty they should also need to pay on the declaration. What such declaration is all about? No creditors are existing at this instance. That means no need to pay any amount to the outside parties. Or creditors are there exist. Company is able to pay debts out of the proceeds through sale of assets. Indirectly, they should need to prove the company is solvent. To prove the solvency, to provide the solvency, the board of directors or the majority of the directors provide a declaration with the affidavit, with enclosures. What are such enclosures? The enclosures are 2 years audited financial statements plus operations of the business. Now, any other party can clearly observe that while seeing the audited financial statements, whether the company is solvent or not, or the operations of the business. Operations of the business means, so clearly, what is the earnings before tax? What are the earnings after taxes? Okay, then how much turnover actually they got? All such other information and ratio analysis, such all things they should need to provide. Along with that, valuation of assets and liabilities by registered valuer. Sir, who is such registered valuer, sir? Registered valuers are legal valuers of any particular business. Even our ICAI, our beloved ICAI also introduced one course called Registered Valuer course. Just a second, I'll show you. Our chartered accountants can also act as a registered valuers. Registered valuation exams by ICAI. If you check here, ICAI registered valuers organization. The persons who got the chartered accountant qualification in the post qualification course, they can attend the ICAI registered valuer examination as well. We can also act as a registered valuers. So if registered valuer value all the assets and liabilities of such particular entity, then they may provide one report along with their signatures and all other stuff. Then the board of directors should need to attach that report also. Sir, for which purpose, sir? This one. Now, based upon the valuations given by such registered valuer, any shareholder or the creditor or any other person can simply believe that the company is in solvent position. Hope you got it. So after proving the solvency position, within 4 weeks, such declaration should be approved by the shareholders. Yes, okay, we are also approving for the voluntary liquidation by passing a special resolution. You know, special resolution means at least 2/3 of the members should need to accept. Am I right, guys? Next, after that, sir, it is going to impact the interest of the creditors as well. That's why creditors should also need to accept out of the creditors, 2/3 of the creditors should also give approval for that. Then once either shareholders approving the special resolution or the creditors approved such declaration, then from that date, we can assume that liquidation procedures commenced. After date of approval, either by shareholders or the creditors, within 7 days, voluntary liquidation procedure initiated, and such information will send to the ROC and the board. Here, board means Insolvency and Bankruptcy Board of India. Sir, after approval of shareholders within 7 days, you should need to provide such information to the Insolvency Bankruptcy Board and ROC as well as Register of Companies as well. Then IBBI, Insolvency and Bankruptcy Board, will appoint liquidator, who is also known as, just now we seen, insolvency professional. So to speak technically, that liquidator is nothing but insolvency professional, which is liquidation professional. Then such insolvency professional take charge of the entire affairs of the company. Then the liquidation procedure will be initiated by such insolvency professional. Then he will realize all such assets. Then he will make repayment to the various liability holders in the particular order as per the Act and as per the rules and regulations defined in the Insolvency and Bankruptcy Code 2016. Then after completion of the entire liquidation procedure, the liquidator or the insolvency professional will submit a final copy to the adjudicating authority. Adjudicating authority means who appointed that insolvency professional. For IBBI statute, the adjudicating authority is Insolvency Bankruptcy Board of India. Okay. In case of Companies Act, the adjudicating authority may be a NCLT, National Company Law Tribunal. Adjudicating authority means the authority who appoints such liquidator is ultimately submitted a final copy. Now, based upon that final copy, such adjudicating authority will pass a winding up order, and it will be sent to ROC within 14 days to struck off the company from the database, from the ROC database. That is the procedure in generally happening in case of voluntary winding up, in case of IBC. Sir, which is a legal procedure, guys. We doesn't have any relation with this legal procedure, to be frankly speaking. Sir, but still, why am I explaining all such issues? To connect the subject without knowing such all legal implications, we may not appreciate in the proper manner. To connect the subject, just I'm explaining all such issues. Okay, fine, sir. We understand in the background story really what is happening in case of voluntary winding up when there is involvement of Insolvency and Bankruptcy Board of India. That's great. Now, if the same situation is going to occur as per the Companies Act 2013, how it will be, sir? Concentrate in very layman approach, just I am discussing. So as per Companies Act 2013, but be careful, guys, all of you, just concentrate this. Based upon this only, we are developing the entire accounting issues. Sir, when there is an involvement of Companies Act 2013 is applicable, compulsory winding up due to making petition by the certain parties. Who can make a petition? Can you please tell me? Petition to whom? NCLT. For NCLT, in case of compulsory winding up, who can make a petition? The petition may be submitted to the NCLT either by shareholders or either by creditors, or maybe either by central government or representative of central government, or maybe by the ROC or any other party. If made a petition to the NCLT or on the sumo motu basis, NCLT may order pass for compulsory winding up. Once the NCLT may order for compulsory winding up, an official liquidator will be appointed by the court of law or the NCLT itself. Official liquidator. One official liquidator will be appointed. Sir, why I'm using the word official liquidator? That liquidator was not appointed by shareholders or the creditors or some other one. The liquidator was appointed by the court of law. That's why we are in generally known as official liquidator. Fine. Sir, once the liquidator will be appointed by the court of law, then shareholders and the board of directors discharging from their rights and responsibilities. Shareholders and the board of directors, both the parties will discharge from their rights and duties. Rights and duties. Why, sir? What is the reason? Can you please tell me, all of you, for a country, 2 prime ministers possible? Not possible. Sir, the authority, the authorized person should be only one person. Once the liquidator appointed means, who is the captain of that company? Liquidator is the captain of the company. That means the entire power should be vested with the liquidator, and no other powers would be, the powers would be, should not be held with any other person. Am I right or wrong? That is the reason why they clearly told that in the Companies Act 2013, once the liquidator was appointed, shareholders and board of directors will lose their all rights and duties. Sir, that means now board of directors do not have any decision to conduct the business activity. That means, can they propose the dividend? Can they take the decision regarding a particular activity of the business? No, they are not having any authority. They are not at all connected with the business decisions right now. But if liquidator something he will order, then they should need to do. That's it. And the shareholders also not having their rights. So as like earlier, shareholders can participate in the general meeting through their voting powers. Shareholders can declare the dividend. Such all rights not vested with the shareholders right now. That is the reason why shareholders are known as contributories. Contributories. Now simply just they are acting as a contributories to the company. They are not acting as a shareholder once the liquidator was appointed in the company. Fine. Now, to start conducting the realization activities by the liquidator. What the liquidator duty? Why the liquidator was appointed? You know, just may know why liquidator was appointed. The duty of the liquidator is pretty much simple. Just he will realize the assets and discharge various liabilities, or making payment to the creditors in a particular order. In a particular order. Am I right or wrong, guys? Once he will complete these activities, then a final copy he will prepare. Final copy he will prepare. That final copy will ultimately, he will submit it to adjudicating authority. That is, here he may submit it to NCLT. Then NCLT may pass an order. Once NCLT may pass an order to struck off the company, then such information NCLT may provide to ROC. Then ROC do such struck off. Then from that particular date, the company is close to an end. The winding up procedure was occurred. We can set to be the winding up order was passed and the winding up procedure also over. Now, in this process, please all of you understand here, in this process, liquidator is altogether a new person to the company without knowing any affairs of the company, how he can realize the asset and how he can make payment to the various parties. For example, we are having certain fixed assets, certain PPE like building, plant and machinery, factory premises, land, vehicles. Sir, do you thought that liquidator will know the real position of that particular assets? No, because he is not the party inside the organization. He is the outside party. So to provide the estimated realizable value of assets and estimated payments made to the various parties, to provide such information, board of directors will prepare one statement. Board of directors will prepare one statement which clearly establish the facts related to the existing status of assets as well as liabilities. Such statement is known as statement of affairs. Statement of affairs. The name itself clearly establishes such fact, which is a statement which represents information related to the affairs of the business. Sir, in statement of affairs, board of directors, what they will provide, sir? Which information they will provide? They will provide estimated realizable value of assets, estimated amounts payable to the various parties like creditors. After that, how much surplus may be available or the deficit may be available to the shareholders. Once they realize the assets, after making the payments, how much surplus or deficit may be available to the shareholders. Can you please tell me all these are the real facts? No, these are estimates based upon the information they are getting internally from the company affairs. Maybe the liquidator, he may go with the same values or he may not go with the same values because outside environment is altogether different. Because here I wrote that one particular building, I put a value of 10 crores. When I go for the bidding, really liquidator in the outside environment, maybe one bidder actually quoted 12 crores. Yes, we may sold for 12 crores. Do you understand? So just the statement of affairs is an information provided by the board of directors to the liquidator to realize the assets and discharging the liabilities for the accurate for the purpose of accurate manner. Do you understand? Okay, fine. Sir, based upon the statement of affairs, liquidators start realizing the assets and discharging the liabilities to a various parties. After completion of this procedure, liquidator should need to prepare one statement, which is final copy. I told you that final copy should need to submit to the NCLT. Such final copy is known as liquidator final statement, which is known as liquidator final statement. That means in the chapter liquidation of companies, basically we are talking about two statements. One is statement of affairs, another one is liquidator final statements. Out of the two statements, we are giving our entire focus on liquidator final statement only. Statement of affairs we are going to discuss at the last instance of the chapter. Is it okay, guys? All of you, then come down, guys. Sir, in problematic issues are the issues we are going to learn with respect to accounting perspective. To be frankly speaking, there is no involvement of accounting in this chapter, guys. Even though there is no involvement of any accounting and the journal entry, I am talking accounting perspective related to problematic issues. Which concepts we are going to deal, sir? Which concepts we are going to deal? One is related to statement of affairs, and another one is related to Section 326 and 327 of the Companies Act 2013. And another one is List B contributories. And the liquidator final statement. Liquidator final statement. Out of which statement of affairs and liquidator final statement, a basic intro, not that intro as well. So what it is, I already told you. Section 326 and 327 and List B contributories, I will tell you at the appropriate time. Still, this concept's not yet over. Just, at least who actually prepare the statement of affairs, who actually prepare the liquidator of final statement. That is more than enough. Okay, guys, this is the time to take the break. Please, all of you, assemble exactly by 8:10 because once I'm entering into these issues, I can't give any break to you. So please, all of you, peacefully, you can take the break for 10 minutes. I already told you approximately for 1 to 1.5 hours, I will give you good intro part of the liquidation. So till now, what you listened, these are highly useful to connect the problematic issues. Okay, guys, go for the break. Guys, now we are in problematic issues of liquidation of companies chapter. Come down, all of you. Problematic topics. So total 4 topics we are going to discuss. One is statement of affairs. Another one is list B contributories. And another one is section 326 and 327. 326 is related to overriding preferential payments. And 327 is related to preferential creditors and the liquidator final statement. Sir, in the order of importance, coming to examination perspective, in the order of importance, you can give importance from reverse order, that is from right to left. First, liquidator of final statement, then 326 and 327, then list B contributories, then finally for statement of affairs. Is it okay, guys? So then how you are going to discuss the entire concept, sir? First, I will discuss statement of affairs, very small part. I mean, I'm not discussing anything about the statement of affairs, but in statement of affairs, how the assets and liabilities are going to represent under various lists. First, I will tell you that part. Why, sir? Then why you are taking that? There is a link, unless otherwise nothing will be there. I don't want to take up that topic, right? So that's why first I will take up very small portion of statement of affairs. Then I'll directly jump into liquidator final statement. I'll spend very good time to explain the things related to liquidator final statement. Then after completion of liquidator final statement, I will discuss about section 326 and 327 itself. So regularly they are testing the questions from 326 and 327 for 5 marks. Actually, these are 5 marks questions from this section. If they might ask question from liquidator final statement, it will be minimum 8 marks, or sometimes it may goes up to 12 marks as well. That is depends. Then after that, I will discuss about the list B contributories, which is also for 5 marks. And if they ask question from the statement of affairs, it will be also around 12 marks, but in very remote chances. In the past 10 examinations or after introduction of new syllabus, if you compare till now, even one time they are not testing question from the statement of affairs. That is the reason why in the importance, I give it to the last bench. Is it okay? Fine. Now, coming to the statement of affairs. In statement, sir, what is the statement of affairs? I already told you. Statement of affairs is a statement prepared by whom? All of you. Is it liquidator or board of director? Statement prepared by board of directors. Ultimately submitted to whom? Liquidator. For which purpose? For the purpose of knowing the affairs of the company, liquidator is altogether an outside party. To have good idea on the affairs of the company, board of directors will provide such statement to the liquidator. And one more thing, the information provided by the board of directors to the liquidator are only estimates only. These are not the real figures. Those are estimates only. Board of directors will provide estimated realizable value of assets and estimated values of creditors need to make pay. Apart from that, is it surplus or deficit? With respect to shareholders' point of view, also they will clearly provide the information in such statement of affairs. Now, to present such statement of affairs by board of directors, they will segregate the entire assets, liabilities, and capital into various lists to provide the information in a meaningful manner. Particular category of assets they are giving under a particular list. That means if a list is related to, let us assume list A, particular category of assets are available in such list. If a particular list is list B, other category of lists are available. Like that, they segregated. So now such list we are going to cover right now, even though we are not explaining the statement of affairs at this stage. Do you agree with me, all of you? Fine. Now, assets, liabilities, and capital. For statement of affairs, how we are going to segregate. Can you please tell me, all of you, assets. First, coming to assets. Assets are broadly categorized into two types. One is ANSP, another one is ASP. This is not like ACP, DSP. This is not like that. Okay. In case of police industry, those are having the different designations based upon their powers and authorities. Okay. DSP, District Superintendent of Police, ACP, Assistant Commissioner of Police. That is altogether different. And the shortcut also not provided in the Companies Act 2013, just for our reference purpose only. Shortcuts. I'm telling ANSP, ASP, such type of words not exist in the Companies Act 2013. Just for my reference or our classroom reference or just for remembrance. ANSP stands for assets not specifically pledged. Sir, assets not specifically pledged means these assets are free from any charge. These assets are not offered as security at the time of availing any loan. These assets are not offered as a security for the debenture holders. These are free from charge. Free from charge. Are categorized under list A type of category, A quality category. You can remember like that. List A, assets not specifically pledged. ASP, assets specifically pledged. For example, a particular building was pledged against availing a bank loan. Now, that particular building we can be categorized under ASP, assets specifically pledged, which is a B list category of assets, assets specifically pledged. Do you understand, all of you? Next, here, one building is there. Let me give that building name is Sardar Vallabhbhai Patel building is there. The building name is Sardar building. Let us assume. So that Sardar building was given as security at the time of availing loan from SBI. A loan from SBI. Let us assume. Now, the loan means which is actually liability. The loan will also be categorized under the same list, which is list B only. The loan is also categorized under list B only. Sir, the asset anyway, building will be categorized under asset specifically pledged, which is list B. We understood. Why you are categorizing that loan also under ASP list B? I am not categorized under ASP, I am categorized under list B. That means list B consists of assets specifically pledged as well as this type of loan is known as secured creditor with fixed charge. You know, charges are two types in generally. You may already learn such concepts in company law in your group 1. Charges are basically two types. Can you please tell me, all of you, what are such types? One is fixed charge. Another one is floating charge. Am I right? What is the difference between fixed charge and floating charge? Floating charge means will move in the water. Fixed charge means will be stable. Am I right? No. That is not the meaning of fixed charge and floating charge. Fixed charge means we are providing a identified asset as a security. Identified asset as a security. Which building we provided as a security we know. That is nothing but fixed charge. Floating charge means we are providing unidentifiable portion of assets. Unidentifiable portion means, sir, we are giving building as a security. Which building? We don't know. We are giving stock as a security. Which stock it is? We don't know. That's why in generally it is known as floating charge. Floating means which is not in identifiable manner, which may increase, which may decrease. But which asset you are providing as a security also we are not mentioning. Do you understand? In case of fixed charge, the charge against that property is identifiable. But in case of floating charge, the charge against that property is an unidentifiable condition. That is the difference. Okay, come back. Now, if you offer a particular asset as a security, now the loan availed by the company based on that particular asset is known as secured creditor with fixed charge. Such secured creditor with fixed charge is also categorized under the list. So basically, assets are grouped into two lists. Assets are grouped into two lists. One is A category assets, another one is B category assets. List A, list B. Under A category assets, free from charge, clean sheet assets, which are assets not specifically pledged, simply ANSP. In list B category assets, they are offered as a charge. They are offered as a security. They are under the charge. So, which are known as assets specifically pledged. The loan which we availed against by offering that particular asset is known as secured creditor with fixed charge. Such a secured creditors also we can categorize under list B only. Fine. So next, coming to liabilities and capital. Liabilities here in generally we can call it as creditors, and the other portion is capital. Creditors means not only the trade payable, which includes all. Okay, creditors. Under that creditors, secured creditors, unsecured creditors. Out of that, actually secured creditors are two types: secured creditors with fixed charge, secured creditors with floating charge. Sir, for a particular loan we are offering as a security means that loan may be having a fixed charge or floating charge. We already discussed secured creditors with fixed charge. That's why in that secured creditors, now I want to discuss only secured creditors with floating charge. Do you understand? Next, the other portion. Sir, there is no security offered at the time of availing that loan, or there is no security to pay amount to that particular liability holder. Then such type of liabilities are known as unsecured creditors. Unsecured creditors are divided into two types: preferential creditors, other unsecured creditors. Capital, you know, preference share capital, equity share capital. Now all of you come here, come to my OneNote. I'm discussing about liabilities as well as share capital. So which is liabilities and share capital. Now, basically the liabilities are broadly categorized into two types. One is secured, another one is unsecured. So secured, actually secured creditors with fixed charge, with the floating charge also. So first, before that, sorry. Yeah, unsecured here again, sorry, fine. Which is fixed charge and floating charge. Unsecured creditors is preferential creditors, other unsecured creditors. Now consider it, all of you. Secured creditors with fixed charge, we already categorized under list B. That's why I am not again discussing about secured creditors with fixed charge here. I already clubbed here secured creditors with fixed charge on list B. That means the remaining issues were secured creditors with floating charge, and under the unsecured creditors, preferential creditors and other unsecured creditors. You know, in share capital, we are having preference equity. Now, the question is, list A, list B over, list C. For which category of liabilities, for which category of creditors we can give list C, sir? After list B, list C, na? List C is preferential creditors. List D is secured creditors with floating charge. List E is other unsecured creditors. List F is preference share capital. List G is equity share capital. And this is also the order of payment. This is also order of payment followed by the liquidator at the time of distribution of the cash which was realized from assets. That means in the order of making payment, whenever we are realizing a particular asset which was offered as a security under the fixed charge, first we should need make payment to that particular liability. Then list C, preferential creditors. Then secured creditors with floating charge. Then other unsecured creditors. Then preference shareholders. Then equity shareholders. Sir, everything is clearly understandable except one thing, sir. Even though preferential creditor is an unsecured creditor, why are giving the preference over the secured creditors with floating charge. Because in your order, you are telling that first we should make payment to the preferential creditors. After that only you can proceed with the floating charge. Why, sir? Why, even though such creditors are unsecured creditors, why you are giving preference? That is the reason why such creditors, such unsecured creditors are known as preferential creditors. How it will happen, I will tell you. Just don't take it in otherwise. Just for simple understanding purpose, I am telling you. For example, in case of movies, a popular movies, the actors which are having the huge fan following. Okay. Whenever they are released such movies in the theaters, what will happen? Very big queue will be there. Very big queue. Okay. So persons will stand like anything from morning, early morning onwards itself, they will standing in the queues in front of the theaters. Am I right or wrong? Then suddenly one good fan group will come. What they will do, they'll put very big cutout of that particular actor. They will do so many activities with milk and some other thing. Certain abhishekas will be there. So many things will happen. And they are crossing this line. They are directly come. They are waiting for tickets. They are having that privilege, They are having that privilege. Sir, even though these are under a line, even though those are the secured creditors with floating charge, even though that fan-based youth or that fan-based group is having a privilege over the secured creditors with floating charge. The reason is they are having that preference. They are having that preference because those are the fans. Even though those are unsecured, they are not in the line. They are not in the queue. They are having that privilege. They are having that power to get the tickets. What happened, without offering tickets to such fans, if they are offering the tickets to the general public, then what will happen, You can imagine the glasses of the entire theater will blast like anything. Am I right or wrong, guys? Those are the fans. That's why the theater management should need to allocate certain tickets, because whether the movie will be going into the flop mode or the hit mode, irrespective of that, that fan following will come, will enjoy the movie based upon that hero. That is the reason why we are giving the preference. As like in the same mode, the Companies Act 2013 also give preference to the certain creditors, even though such parties are completely unsecured. They are not having any security. Still, they are need to receive in the first instance before making payment to the security creditors with floating charge. But sir, what is the reason, sir? Such all things we are going to explain where here. Section 326 and 327 is there, na? There I will explain clearly, because 326 is related to overriding preferential payment. 327 is related to preferential creditors. Sir, who are such preferential creditors? Why you are paying the first instant itself before making payment to the secured creditors with floating charge, even though preferential creditors are unsecured creditors? All such reasons I clearly explained in such specific sections at that instant. Is it okay, guys? Fine. Now, please, all of you, let me know. I will quickly ask some questions. List A, which category of assets? List A. Quickly, guys, all of you, please participate through the query box. List A. Is it ASP or ANSP? Assets not specifically pledged. List B, assets specifically pledged along with secured creditor with fixed charge or floating charge. Secured creditors with fixed charge. Next, list C. List C. Those are the charming persons. C for charming. Charming means even though those are unsecured, they are highly attractive person. That's why we are paying before making payment to the secured creditors with floating charge, which are preferential creditors. Those are unsecured creditors only. List D. Secured creditor with floating charge. Come on, guys. After that, E. List E. Which type of Which type of parties those are? Preferential. Sorry, not preferential. Other unsecured creditors. Other unsecured creditors. Then after that, list F. Then preference, shareholders. Then finally, list G, equity shareholders. These are the list, guys. Sir, for which purpose these lists we are in generally using? For the purpose of presentation of the statement of affairs. I'm not discussing anything about the presentation of statement of affairs, but in such presentation, we are using such a lists presentation. For that purpose, just I introduced the different list. But how the board of directors will present the statement of affairs, which format they are in generally following, such all stuff we are going to explain at the end of the chapter. Just leave it or put aside the statement of affairs. Something related to the statement of affairs, just like as a trailer. Before releasing the movie, one trailer will be released, right? Like the trailer, in trailer, what they will show. You don't know the entire story, but some hints. Am I right? Who is the hero? Who is the villain? What is the beginning? What is the ending? Like that, certain scenes will come and will go. In the similar mode, statement of affairs. Who will prepare? Board of directors. To whom this is handover? Liquidator. In statement of affairs, how the information is going to present? Through lists. List A, ANSP. List B, ASP and secured creditors with fixed charge. List C, preferential creditors. List D, secured creditors with floating charge. List E, unsecured creditors. List F, preference shareholders. List G, equity shareholders. That's it. That is more than enough. Now, all of you please come to the concept of liquidator final statement, guys. Come to liquidator final statement, all of you. So, which is very much important topic in the chapter liquidation of companies. You may expect the question. Okay, if they ask the question from liquidation of companies, you can give the more importance to the liquidator final statement. Before proceeding with the liquidator final statement, first, I'm asking a quick question, guys. All of you, please participate here. Who will prepare the liquidator final statement? Who? I already told you, and please, all of you, provide your answers quickly in the chat box. I'll check who will prepare. Who will prepare? Nobody is providing the answers here. Almost the last message in the query box in and around 8:28. Quickly, guys. All of you, please provide the answer. Who will prepare the liquidator final statements? Is there any delay or you are not providing the answers? Let me know. Yeah, now I got. Fine. Who will prepare the liquidator final statement? Absolutely. Liquidator will prepare. Fine. Next question coming into my mind is when he will prepare. All of you, please participate again. When he will prepare. When means at which particular point of time this will be prepared. All of you, please let me know, guys. In which particular point of view liquidator will prepare. Neha Verma, who will prepare means you are giving the answer board of directors. No, still your mind is there in statement of affairs only. Come to liquidator final statement. Who will prepare? Liquidator only. Okay. When? Come on, guys. When he will prepare? When means in particular scenario he will prepare. At which particular point of time he will prepare? When winding up of the company, at last, after all settlement, at the end of the year, after all the liabilities and assets has been settled, when the company has been liquidated and the outside liabilities settled. Super. I will tell you practically as well as academically here. Once the board of directors and shareholders are discharged from their duties and the rights, liquidator will be appointed on their place. I told you the process of liquidation will not come to an end within days, within months, or within weeks. It may run over some number of years as well. Now, during the process, liquidator should need to prepare financial statements as well. In the general course, he will prepare the financial statements. Yes, generally that's whose responsibility to prepare financial statements, board of directors. But here, board of directors will discharge from their duties and rights. That's why it is whose responsibility to prepare financial statements, sir? Liquidator. Along with the preparation of financial statements for each and every year, liquidator should also prepare liquidator statement, actually, which is not a final statement. He will prepare a liquidator statement. In that liquidator statement, what he will provide, till date, what are all the different assets realized by me? What are all the different liabilities repaid by me? What is the surplus cash available with me? Simple, which is an R&P statement for each and every year. Different assets realized by me, different payments made by me, available with cash on hand. And the financial statements along with this liquidator statement will be submitted at the end of each and every year to the adjudicating authority. Adjudicating authority means that is appointed. The person who appointed the liquidator, to that person, the liquidator should need to submit in generally court of law, the NCLT, whatever the case may be, or the IBBA, Insolvency and Bankruptcy Board of India, whatever the case may be. After completion of realization of all assets and all the liabilities, then finally liquidator should need to send a final copy to the adjudicating authority. That final copy is accompanied by such a liquidator final statement. That means liquidator final statement, when they are in generally prepared at the final stage, that is after realization of all assets and discharging or making payment to all liability holders, then liquidator will prepare the final statement, and which should need to be submitted ultimately to the adjudicating authority. Adjudicating means the person who actually appointed the liquidator. Because why I'm telling, the liquidation process or the accounting issues are common, whether the liquidation procedure adopted as per IBBA or as per Companies Act 2013. That's why the common word I am using, which is an adjudicating authority. Sometimes it may be an LCLT, sometimes it may be Insolvency and Bankruptcy Board of India. Is it okay? Fine, all of you. The next question coming into my mind is, sir, liquidator at the time of presentation of his final statement, all the values are estimates, are real values. Are A for estimate, B for real values. Please provide all of your answers. Is it A or B? Liquidator is going to prepare the final statements based upon estimated realizable values, based upon the real realization values. A or B? Answers quickly, guys. All of you. Is it A or B? Liquidator final statement is going to be prepared based on estimates, based upon real realized values. Nobody is providing the answer, yaar. Please, all of you participate quickly. Is there any delay? Something or nothing is coming to me. Now participation is there. B realized values, B realized values, B real values. Someone, Bindu Sai, is telling A. Hariram is telling A. If it is the statement of affairs, they will prepare based upon the estimated values, ma. If it is the statement of affairs, then here the values are estimates. But in case of liquidator final statement, which is not estimate, which is real, what happens once the liquidator submitted his final statement to the adjudicating authority? Nothing will be there in the company. So that's why he will prepare with all the real realizable value of assets, real realized value of assets, as well as at the value at which he made settlement to the various parties. Is it okay? Fine. Next. Sir, then after asking these many questions, you can simply predict that how the liquidator final statement will look like, which is a simple receipts and payments account, which is a simple receipts and payments account. For the purpose of realization of receipts, no order is required to follow by the liquidator. In generally, which order they will follow? Liquidation order in generally he will follow. What is the liquidation order, sir? Liquidation order means to liquidate a PPE, it will take more time. To liquidate the inventory, it will take less time. The better word is not the liquidate. I will put this one. Which order they will follow, sir? What is that order? The speedy realization is known as which order, guys? What is that? I mean, the correct word, I unable to tell that, but hope you understand my mindset is. That means first he will realize those assets which we can realize in the speedy manner. Anybody can please put that? What is that word? What is that? For those assets which have the speedy realization, such assets are known as liquid assets. Correct. Those are liquid assets. Now I got it. First, he will realize liquid assets. Yes, you are right. Based upon the liquidity only. I thought of, I used the same word before that as well. Okay, fine. Based upon the liquidity order, he will follow. Not the liquidation order. Liquidity. He will follow the liquidity order. Liquidity means for those assets which have the high liquidity, first he may realize. That is a common thing. After that, PP and such all other stuff, it will take much more time. At the later point of view, they may sell all such assets. In generally, this order was not clearly mentioned in the Companies Act 2013. That is based upon the timing and based upon the quotes given by the outsiders. Such all other stuff will decide which asset should need to be realized first, which asset should need to realize at later. But the general scenario I told you, which he generally follow the liquidity order. Coming to the payments. So related to the payments, which order they might follow, sir? Related to the payments. First, liquidator should need to incur legal charges. Why, sir? Sir, court fee, to make a petition and such all other stuff, they incur certain expenses. Such all things will be there, right? That is legal charges. First, they should need to incur. After legal charges, they should need to incur liquidator remuneration. Liquidator will not provide his services at free of cost, right? Liquidator will provide his services by taking certain remuneration. You might see in the same concept in case of dissolution of partnerships as well. In case of dissolution of partnerships, in the concept of piecemeal distribution, certain partner may acting as a liquidator, okay, to complete the entire dissolution process. At that point of time, he may charge also certain commission here, which is known as liquidator remuneration. After that, liquidation expenses. So liquidation expenses means at the time of realization of assets, we may offer for certain bids or maybe certain advertisements, any certain other expenses, stamp duties and such all stuff, which are liquidation expenses. After liquidation expenses, you may payment to preferential creditors. Sir, what about secured creditors with fixed charge, sir? Then we should need make payment to secured creditors with fixed charge, na? Why I am not discussing anything about secured creditors with fixed charge, you know? Whenever we are realizing amount from a particular asset under receipt side itself, for example, please all of you concentrate, a certain building was offered as a security at the time of availing the bank loan. That bank loan is a secured creditor with fixed charge. Now, from the building, I realized a cash for 1 lakh and the loan amount was 60,000. The loan amount we should need to repay at that instant itself. Then the remaining 40,000 only I can consider it as a surplus from the realization of building. That's why secured creditors with fixed charge, you can clearly written down under receipt side itself. But under receipt side, you should not shown as a positive figure. You should shown as a negative figure. It should need to be reduced from secured creditors with a. Sorry, you should need to reduce from assets specifically pledged. Do you understand what I am telling you? Just hold for some time. I'll clearly explain each and everything. But just I am telling you, if any secured creditor with fixed charge is there, it should not be shown under payment side. It was shown under receipt side only through reduction from asset specifically pledged, the net surplus from the asset specifically pledged only is the net receipt. Okay, fine. So in the order, legal charges, liquidator remuneration, liquidation expenses, then that's why preferential creditors. After preferential creditors, we may make payment for security creditors with a floating charge. Tell me guys, please, all of you participate. After security creditors with floating charge, other unsecured creditors, but you can use the word unsecured creditor as well. Why I'm specifically using other unsecured creditors? Preferential creditor is also unsecured creditor. Other than preferential creditor, who are all the unsecured creditors remaining, you can call it as other unsecured creditors. But for the time being, I'm removing the word other. You can call it as unsecured creditors. Then preference shareholders. Then finally, equity shareholders. Am I right or wrong? Now the same information, how I need to represent, sir. I'm going to explain through my notes. Concentrate here. Which is the liquidator final statement. Receipts under left hand side. Payments under right hand side. Amount column. It is a typical receipts and payment account. We will start our journey with assets not specifically pledged. Those assets which are not offered as a security, first you can consider it here. Then assets specifically pledged. Those assets which are offered as a security at the time of availing any loan, or those are acting as a security for any specific creditor. Then don't make it present in the outer column, just make it present in the inner column. Because from which secured creditors with fixed charge you need to reduce. The remaining surplus amount only you can write down. Then so many students, you may have so many questions here. I will resolve all such questions through different cases. Please, all of you concentrate. Question number 1 is, concentrate all of you. Sir, building value was 1 lakh. This building was offered as a security for a bank loan. The bank loan amount was 60,000. Just now I discussed this. If this is the case, then the building is a ASP and the bank loan is a security creditor with fixed charge. No doubt about it. Now, at this instance, 40,000 will be the surplus from the ASP. That 40,000 we can make it present to the outer column. That is not the case. While realizing the building, we got 1 lakh. That's okay. But the bank loan was 1,60,000. Then what can I do at that particular point of time? That means through realization of building, entire bank loan was unable to repay. Still there is a short of 60,000. Then what I will do, here realization through building, 1 lakh I should need to consider, and less secured creditor with fixed charge right now, not 1,60,000. Out of 1,60,000, 1 lakh is only the secured creditor with fixed charge. The reason is how much portion of the building can able to cover the portion of the bank loan, only to the extent of 1 lakh. To the extent of 1 lakh only we can treat it as secured creditors with fixed charge. Fixed charge. Sir, what about the remaining 60,000, sir? Remaining 60,000 was now it is unsecured creditor. Do you understand the logic here? So that's why only 1 lakh only we can need to reduce in the inner column, and the outer column from that building surplus is nil. Then at the time of making repayment to unsecured creditors, we should need also club this 60,000 also into the unsecured creditors. Then you can make repayment. That's why out of this 1,60,000, only 1 lakh only coming into the picture as a secured creditors with fixed charge. Remaining 60,000, you can treat it as unsecured creditor. Do you agree, guys? All of you? All of you with me? Fine. Next. Sir, call money from partly paid up shares. Now, what is this all about? I will discuss at the final stage. Just you can consider only do 2 things, ANSP and net surplus from the ASP. What about this call money from partly paid up shares and all other stuff we will discuss at the final stage of liquidator final statement. Come to the payments. Come to the payments, all of you. First, legal charges. Fine. Then liquidator remuneration. Then liquidation expenses. Then secured creditors with floating charge. Then preferential creditors, unsecured creditors, preference shareholders, equity shareholders. Sir, these two are wrong order, na? First, we should need make payment to preferential creditors, na? After that, only secured creditors with floating charge, na? Yes. Order is wrong, but the presentation is correct. After making payment of liquidation expenses, we should need make payment to the preferential creditors only. Before making payment to the secured creditors with floating charge, we should need make payment to the preferential creditors only. You are absolutely correct. But in the presentation, first you should need to present the secured creditors with floating charge. After that only you should need to present the preferential creditors. Why, sir? The reason is very much simple. Preferential creditor is an unsecured creditor. Other unsecured creditors is also unsecured creditor. Just the logic behind the presentation of preferential creditors after secured creditors with floating charges, all the unsecured creditors should need to present at one place. Secured creditors with floating charge should need to present at one place. Except this, there is no rocket science involved here. That is the reason why in the presentation wise, after presenting the secured creditors with floating charge, only we are generally presenting the preferential creditors. But really, at the time of making payment, liquidator will follow the order. First, he should make repayment to the preferential creditors. Then only after that, he will come to the secured creditors with floating charge. Do you understand, all of you? Next, guys. Sir, most of the times, secured creditors with floating charge. Who are secured creditors with floating charge, sir? Most of the times, debenture holders. Most of the time, secured creditors with floating charge were debenture holders. Why, you know? As per the Companies Act 2013, whenever debentures are issued by the company, debenture holders will appoint the debenture trustees to protect the interests of the debenture holders. And at that particular point of time, debenture trustees itself, they are having certain agreements with the company that if at any particular point of time the company is going to liquidate, or if something will be happen, then at the time of liquidation, you may not have a sufficient surplus at that particular point of time. Our interest may badly affected. So to protect that, on all the group of assets, we want to take a general charge, which is a floating charge. So that is the reason why in generally debenture holders is having charge on all assets, not on identifiable assets, just charge on all assets, which is floating charge. Is it okay, guys? All of you. Next. Sir, who are these preferential creditors, sir? Who are these preferential creditors? Just give some time, because at the final stage of liquidator final statement, I'm going to this topic only, that is section 326 and 327, which is related to preferential creditors and overriding preferential creditors, where I will clearly explain which type of creditors are coming under the preferential creditors and what is this concept of overriding preferential payments. Also, I'm going to explain there. Okay, just time being, you can ignore who are preferential creditors, then unsecured creditors, then preference shareholders, then equity shareholders. Super. And the next question coming into my mind is, what all about liquidator remuneration, sir? How it should need to be calculated? How the liquidator remuneration we can calculate? Concentrate. Still time is there, right, for us? Yeah, very good time is there. Just a moment. Today, most of the things are in theoretical nature, because the liquidation of companies theory is a little bit lengthy. Once we can able to cross this stage, then peacefully we can give our entire concentration on problems. Fine, guys, concentrate. The liquidator remuneration is based upon percentage of value of assets he realized, or it may be based on percentage of payments made to various parties. For example, for better understanding, we can take an example. Sir, it was clearly mentioned in the problem that liquidator will get 5% remuneration on assets not specifically pledged. Only on the realization of assets not specifically pledged. In the current year, assets not specifically pledged was 5 lakhs, let us assume. Now the remuneration is 5 lakhs into 5%, which is 25,000. Such a simple task. If it is based on percentage of value of assets realized. No, sir. The example is, for example, on the total assets, that is either ANSP or ASP. Then you can put together. Then on that value, just you can apply the percentage. Then you will get the liquidator remuneration. If the remuneration is based on percentage of payments made to various parties, then is little bit you should need to work out in cautious mode. I'll tell you the reason. Please concentrate. Let me take the example for better understanding again. So the liquidator commission, as per the information given in the problem, was 2.5% on payment distributed among the shareholders. The commission was 2.5%, that too based on payment distributed among the shareholders. They may be equity shareholders or preference shareholders. In the question, preference share capital is there for 5 lakhs, equity share capital is there for 4 lakhs. And cash on hand with the liquidator before making payment to shareholders was given at 6 lakhs. Now all of you please concentrate. What he given? Now with the liquidator hand, he have 6 lakh cash. Distribute among preference shareholders and equity shareholders. Preference share capital is there with me 5 lakhs and equity share capital with me 4 lakhs. And the liquidator commission or the liquidator remuneration is 2.5% on payment made to shareholders. That is the point he is conveying. Now what my question is, liquidator remuneration is how much? How much amount you can able to make payment to preference share capital? How much amount you can make payment to equity share capital? That is my question. These all are facts of the question. Hope it is clear. One more time repeating. Preference share capital 5 lakhs, equity share capital 4 lakhs, cash available with the liquidator was 6 lakhs. Liquidator remuneration is 2.5% on amount payable to shareholders. Then liquidator remuneration how much? Preference share capital how much? Equity share capital how much? Can you please all of you tell me your answers quickly? I'll check. Nothing I told you. Just I am asking you. Liquidator remuneration how much? Amount payable to preference share capital how much? Amount payable to equity share capital how much? Please quickly guys, give your answers. You should need to participate. Then only you are with me. Otherwise you are disconnected with the subject. No single answer coming to me till now. At least one answer guys. Either liquidator remuneration or amount payable to preference shareholders or amount payable to equity shareholders. At least one answer quickly. Preference share capital 5 lakhs. Okay. So many members telling that at preference shareholders we are paying 5 lakhs only. Remuneration 15,000 someone told. Okay. Equity share capital someone told 1 lakh. Okay. What about other answers? Quickly guys. Only 3 members participated. They gave 3 answers. What about others? Another answer coming. Sir, preference share capital is 5 lakhs only. Okay, same answer. Equity share capital 1 lakh and liquidator remuneration 15,000. Okay. So all are giving these answers only. Okay. Let me check with my hands. Now, consider all of you. With the liquidator, he is having 6 lakh cash, right? For example, if liquidator out of such 6 lakhs in the order of payment, if you make payment to the preference shareholders, he can able to pay entire 5 lakhs. No doubt about it. He can able to pay entire 5 lakhs, 6 lakhs, out of which that is cash available. before making payment to the preference shareholders and equity shareholders 6 lakhs. If he can pay payment to preference shareholders, then he can able to pay entire 5 lakhs, no doubt about it. At the time of making preference shareholders, he should also take his remuneration as well. Then liquidator remuneration is 2.5% on payment made to the shareholders. That is 5 lakhs into 2.5%. How much? 5 lakhs into 2.5%. Which is 12,500. Super. Now, after making payment to preference shareholders as well as after taking his remuneration, how much cash available here? 87,500 cash is available, which I can tell it as cash available with the liquidator. Cash available with liquidator before making payment to equity shareholders. Do you agree, all of you? Next. Sir, now this 87,500. Now this 87,500, can I directly distribute to equity shareholders? No. You know the reason? If I distribute 87,500 to equity shareholders, then for liquidator as a remuneration, how much I can give? 0. I am unable to give. That means this 87,500 should need to distribute to equity shareholders as well as liquidator remuneration. I should need to distribute to equity shareholders as well as liquidator. Then my question is, how much I can able to distribute to equity shareholders? How much I can able to distribute to liquidator remuneration? That is my question. I need to segregate. I know one thing, right? If 100 I need to distribute to equity shareholders, then 2.5 rupees I should need to give to liquidator. Tell me, yeah. If 100 I should need to distribute to equity shareholders, 2.5 I should need to give to liquidator. The total will be 102.5, which is equal to 87,500. For 102.5 is equal to 87,500. Then for liquidator 2.5, how much? Which is 2.5 multiplied with 87,500 divided by 102.5. Quickly, guys, all of you. 87,500. So the liquidator remuneration, here I am got 2134. Am I right? 2134 is the approximately liquidator remuneration. And the amount payable to equity shareholders, 87,500 minus 2134, which is 85,366. 85,366. Now the answers, consider all of you. The total liquidator remuneration, here 12,500 plus here 2134. 12,500 plus 2134, total 14,634. Amount payable to preference shareholders, 5 lakhs. Amount payable to equity shareholders, 85,366. Only one answer is correct. This answer is wrong. This answer also wrong. So, what your final conclusion, sir? Why you are trying to establishing all these things? Whenever the cash is insufficient to make payment to a particular party as well as to the liquidator, then you are unable to distribute straight away to the particular party. Then how you should need to work out the liquidator remuneration at that particular scenario? Liquidator remuneration is nothing but liquidator remuneration is equal to percentage of commission divided by 100 plus such percentage of commission into cash available before distribution of amount to that particular party as well as liquidator. If you have a doubt, you can check this equation. Percentage of commission 2.5 divided by 102.5, 100 plus percentage of commission multiplied with cash available before making settlement to that party as well as liquidator, which is 87,500, which is cash available. The same fact I'm telling here as well. If the cash is insufficient, then rate of commission divided by 100 plus rate of commission multiplied with cash available before payments is the formula you should need to apply to know the liquidator remuneration. If the cash is sufficient, no need to think about all these issues. Simply that amount payable to that particular party into percentage of commission, you will get the liquidator remuneration. Is it okay, guys? All of you with me? All of you with me? Can I proceed? Okay. Why 102.5, sir? Why 102.5? Just now I told you clearly why 102.5 means, sir, just I assumed that amount payable to equity shareholders was 100. I don't know how much amount payable to equity shareholders. To resolve that something I should need to assume. How much amounts are? Let us assume you can assume 100 as amount payable to equity shareholders. If you are able to pay 100 to the equity shareholders, then how much amount you should need to pay as a liquidator remuneration? 2.5 rupees. That means 100 plus 2.5 is 102.5, which is equal to the cash available before making payment to equity shareholders as well as before making payment to liquidator. Before making payment to equity shareholders as well as liquidator remuneration, how much cash you are with me, how much cash available with me or with you, which is 102.5. Such 102.5 is equal to 87,500, which is cash available with the liquidator before making payment to equity shareholders as well as liquidator. Now, if it's 102.5, which is equal to 87,500, then for 100, how much? Then for 2.5, how much? You can simply calculate. That is the reason why I'm considering this 102.5. Okay. Fine. Can I proceed further, guys? Can I proceed further? Sir, this could be done on the 6 lakh also. Remuneration 14,634. Yes, if you want, you can do it. Not an issue. If you want, you can do it. Okay, but that might confusing. So that's why on the basis of order, one by one, if you do it, then you will have a clarity. Gupta, I too agree. Not an issue. Okay. Yeah. Fine, sir. I'll proceed further. Hope you understand the concept of liquidator remuneration. There still I need to issue so many important issues with respect to liquidator final statement. Next question is, sir, cash available with the liquidator, cash available with the, I'm not talking about liquidator remuneration. I'm talking about another issue. Please concentrate. What is that issue? If I explain, if I put the scenario, then you can get the concept or you can understand the concept. Concentrate. Cash available with the liquidator. 1 lakh. For equity share capital, paid up value is therefore number of shares were 10,000 and each share paid up value is 7. That's why 70,000 is the paid up value. Okay. And the preference share capital is also there, which is for 50,000. Now, all of you, before making settlement to the shareholder, cash available with the liquidator was 1 lakh. Now, can you please tell me, all of you, out of this 1 lakh, first to whom I should need to pay? First to whom I should need to pay? Is it preference shareholders or is it equity shareholders? Preference shareholders, right? Now, this 1 lakh, I should need to pay to the preference shareholders first. So 1 lakh minus 50,000. Then the remaining cash available with the liquidator was 50,000 before making payment to equity shareholders. Now this 50,000 I should need to distribute among these 10,000 equity shareholders. That is, for each and every equity shareholder, I should need to pay 5 rupees per each. Then for equity shareholders, I need to pay 50,000. There is a deficit in equity shareholders point of view. That's okay, fine. Hope you can easily appreciate this scenario. But this is not my point. This is not my discussion. My discussion is concentrate. Preference share capital is not 50,000. Preference share capital is 1 lakh. This is my scenario. Preference share capital is 1 lakh. And equity share capital 10,000 shares are there, partly paid up, which are 7 rupees. And the cash available with the liquidator is also not 1 lakh. The cash available with the liquidator was now changed to 80,000. Now consider, guys, all of you. This is different scenario I'm explaining. The previous scenario is understandable in the straight away. Now, the cash available with the liquidator is insufficient to make payment to the preference shareholders. Do you agree? The cash available with the liquidator is insufficient to make payment to the preference shareholders. If at any particular point of time, if the cash available with the liquidator is not sufficient to make repay, not only to the preference shareholders, to any other party as well. If any partly paid up shares are there, then liquidator have a right to ask money from the uncalled capital to that extent of unpaid value at a maximum portion till face value. That means if here face value is 10 rupees, here liquidator can make a call for to the extent of 3 rupees straight away. If he want, he can make a call. For example, if he can make a call from the 10,000 shareholders, then call money receive from equity shareholders for 10,000 multiplied with 3, which leads to 30,000. Then 80,000 plus 30,000 cash available with the liquidator before making payment to preference shareholders for 1,10,000. Tell me, guys. Now liquidator can able to make payment to preference shareholders. How much? 1 lakh. Now 1,10,000 minus 1 lakh, 10,000. Such 10,000 cash we can able to distribute among equity shareholders. For equity shareholders, how much we can able to distribute? 10,000 amount among 10,000 equity shareholder. For each equity shareholder, we can distribute 1 rupees per share. Now all of you please concentrate. Sir, why you are asking money from equity shareholder at the rate of 3 rupees then? Because you are asking 3 rupees from equity shareholders. Again, you are giving 1 rupee share to the equity shareholder. Rather than doing all such things, asking 3 rupees, again giving 1 rupee, it is better to ask 2 rupees. Do you agree, guys? We are asking 3 rupees from equity shareholders. Again, finally, you are issuing 1 rupee to the equity shareholder. Rather than asking 3 rupees and giving 1 rupee, asking 3 rupee and giving 1 rupee, it is better to ask the net amount, which is 2 rupees. If I ask 2 rupees, what will happen? 10,000 multiplied with 2. It will become 20,000. I required only 1 lakh. Payment made to the preference shareholder 1 lakh. After that, cash available nil. Okay, fine. That means how much amount you as a liquidator you can call from the particular party is depending upon scenario in which the liquidator is actually making payment to the party. In which scenario he will be, you need to check. Then how much capital we can make a call from the unpaid shareholders or the shareholders who are partly paid up, you can know. Do you agree, guys? All of you, this one? No confusion, nothing here. Sir, if any partly paid up shares are there, if the cash is insufficient with the hands of the liquidator, then liquidator have a right to ask money from that partly paid up shareholder. But how much amount we can make a call, then liquidator should need to check depending upon scenario to scenario. Then he will make a call accordingly. Then he will make a repayment to the other party. That is one thing I need to discuss. And one more important issue. Before making payment to the equity shareholders, you should always make payment to the preference shareholders. And one more issue, please concentrate. So many issues are coming. First, let me take the scenario, then I will put the issue. Sir, cash available with the liquidator, let us assume 1 lakh. Now, unsecured creditors are there for 1,50,000. Preference share capital, partly paid up, 10,000 shares are there into 5, 50,000. Equity share capital, 10,000 shares are there, or 1 lakh shares are there. partly paid up, 7 lakhs. Now, cash available with the liquidator before making payment to unsecured creditors is 1 lakh. Now, can you please tell me, all of you, in this scenario, is it liquidator can able to repay the entire amount to unsecured creditors? No, 50,000 is insufficient. Now, whenever liquidator is not having sufficient cash on his hand, he can go for call. Now, my question is, in this scenario, liquidator can make a call to preferential shareholders or equity shareholders first. Liquidator can go for call to ask money either from preferential shareholders or equity shareholders. Please put your answer. All of you, please, all of you participate here. So many questions actually persons are asking, sir, if the different classes of equity shareholders to whom we should need to make pay first. All such scenarios are also coming. Okay, one by one. Okay, no worries. Mr. Bunreddy, no worry. Okay, I'll tell that one as well. Ms. Pooja, anyway, company is liquidating. So what if the equity shareholders do not pay, sir? Because even if they pay, they are not going to get it back. Your point is good, Amma, from your point of view, but Companies Act 2013 doesn't accept for that, because equity shareholders are the real owners of the company. They have the ability to participate in the profits, right? Because if they have ability to participate in the profit, they should also need to incur the risk as well. That is the why. That is the reason why liquidator can able to ask money from the equity shareholders. That too also not for the entire loss, na. How much amount they can able to ask? Up to the face value, due to the concept of limited liability. But up to the face value, shareholders was liability was already fixed. That's why they can able to ask. Fine. Now the question answer. Can you please tell me, can I make a call from preference shareholders or equity shareholders? Sir, I think first equity shareholders, equity, both, sir, because amount from equity shareholders is not sufficient. Okay. First, I'm asking the question first to whom we can make a call. In the first instance, definitely equity shareholders gets, not the preference shareholder. You know why? Preference shareholder will have a preference in only in two modes. One is at the time of distribution of the dividend, preference shareholders will have a first preference to get the dividend. And at the time of liquidation of the company, preference shareholders will have a preference to get the money from the company. For taking only preference shareholders, they will standing on the first line. For giving always preference shareholders, they might stand on the backbench only. They are not ready to give, because those are the not the risky persons, those are the risk neutralized persons. Always for asking first, the choice of issue is equity shareholders. If the amount which we should need to recover from the equity shareholders is insufficient, then we can ask for the preference shareholders. That means first we should ask money from the equity shareholders. That is 1 lakh multiplied with 3 rupees. Here 1 lakh multiplied with 3 rupees means 3 lakhs, which is sufficient now. Who told which is insufficient? Which is 3 lakhs, which is sufficient. You can get 3 lakhs money. Is it okay, guys? All of you. Then for such 3 lakhs, then cash available with the liquidator will be 4 lakhs. Out of such 4 lakhs, he can make able to payment to unsecured creditors, 1,50,000 unsecured creditors. Then the remaining balance will be 2,50,000. Now, out of this 2,50,000, to whom I should need to make payment? Preference share capital, less preference shareholders. Preference shareholders, how much? 50,000. Then the remaining amount is how much? 2 lakhs. Again, this 2 lakhs to whom I should need to distribute? This 1 lakh equity shareholders. 1 lakh equity shareholders means per head 2 rupees. Sir, earlier we asked 3 rupees from them. Again, you are giving back 2 rupees. Rather than asking 3 rupees and giving 2 rupees, it is better to give. It is better to ask. Sorry, it is better to ask 1 rupee per each equity shareholder. Tell me, guys. That's why this call is known as notional call. This is not a real call. This call is known as notional call. Once if you are working on the notional call basis, then you should know how much real call you can be made. Now, if I go on the real call basis, cash with the liquidator was 1 lakh before making call. If you make a call to the equity shareholders, then you will get 1 lakh into 1 rupee. That is another 1 lakh you are getting, 1 lakh plus 1 lakh, 2 lakh you are getting. From such 2 lakh, unsecured creditors, 1 lakh 50,000. Then you are having 50,000 cash available with the liquidator. From such 50,000, they can able to make payment to the preferential shareholders 50,000. Then cash available with the liquidator was nil. Do you understand my point, guys? Always. Sorry. Do you get that point, all of you? Sir, to know the real call made from the equity shareholder, first I will continue the procedure with the notional call. Once after getting the notional call amount, if any amount is again distributable to the equity shareholders, from that concept, I need to check the final call. That is the concept I want to try to build here. That is the concept I want to try to explain here. Hope you understand. Next. Fine. The next issue, still 10 minutes time is there. Please all of you participate. Last 10 minutes. Very beautiful concept. Most of the students may do mistakes at this stage only. Please let me explain further more concept. Please all of you allow me, guys. Yeah. This is the next case. What is the case? Surplus available to the liquidator, or you can call it as cash available with the liquidator after making payment to all outside liability holders. There is no preferential share capital. Preferential share capital is completely taken out from the box. Cash available with the liquidator was 5 lakhs. And now the equity share capital scenario was, earlier someone asked questions. Sir, if different classes are there, how we should need to distribute? That one I'm explaining right now. Please concentrate. 10,000 shares are there. That is one class type. Face value 100, paid up value also 100. You can call it as class A. You can call it as class A type of shareholders. Another class will be there, which are class B type of shareholders. Total 3,000 shares are there. Face value again 100, but paid up value was 50. Another class C shareholders, 1,000 shares are there. Face value was 100. Paid up value was 20 rupees. From here, what you can observe simply, guys, can you please tell me? In all the cases, face value is same, which is 100. But the paid up value is different from class to class. Then my question is, how we should need to distribute this 5 lakhs among this various class of shareholders? If one single class is there, you can distribute equally. I do agree. But here different classes of shares are there. Then how we should need to distribute? Please concentrate. Here I will tell you, I will explain you two methods. Which method you are comfortable, you can follow that method. But one method is pretty much logical and another method is pretty much simple. In ICA textbook, which method they are giving, sir? In some problems, they are mentioning method number 1. In some problems, they are following method number 2. So that's why any method can be acceptable universally. Concentrate. The same scenario I'm explaining here. So just let me put the facts here. Surplus 5 lakhs. That is cash availability with the liquidator. Total 3 classes of shareholders are there. Class A, Class B, Class C. May I know, let me start with the face value, all of you. Face value with Class A, Class B, Class C. 10,000 into 100. How much? 10 lakhs. Yeah, 10 lakhs is the total face value. For Class B, 3,000 multiplied with 100. How much? 3 lakhs. And a Class C, 1,000 multiplied with 100. I think so, which is 1 lakh. You can put the total column also as well. Total, let me know. Total 10 plus 3, 13, 30 plus 1, 14 lakhs. Fine. What is the paid up value, guys? Paid up value. Here, total 100 means 10 lakhs. Here, out of 100 rupees, 50 rupees is only the paid up value. That's why, which is 1,50,000. And in Class C, 1,000 shares into 20, that is 20,000. Now total paid up value how much? 11,70,000. Now I'm asking a question. Please all of you concentrate. The total cash available with the liquidator was 5 lakhs and the total paid up value for all the equity shares were 11,70,000. Now in the overall, irrespective of the type of class, just don't think about each and every class separately. Just in the overall, for that organization, if liquidator on his hand 5 lakhs, he unable to make payment for the entire 11,70,000. That means there is a deficit. May I know deficit how much it is there? Deficit equal to 11,70,000 minus 5 lakhs. How much? 6,70,000 deficit is there. Now that deficit you should need to distribute among the various class of shareholders in the ratio of the face value. Now the entire deficit, once again I am telling you, the deficit of rupees 6,70,000 we should need to distribute on the ratio of face value 10:3:1. Now 6,70,000 multiplied with 10 by 14, 4,78,571. Okay. Next, 6,70,000 multiplied with 3 by 14. It will be 1,43,571 and 6,70,000 divided by 14. 47,857. Now, after distributing the deficits, may I know the class A paid up value how much? 10 lakhs minus 4,78,571, which was 5,21,429. Here 1,50,000 minus 1,43,571, which is 6,429. Here 27,857 negative. What is the meaning of this, sir? After distributing the deficit, the class of shareholders for which the figure was negative should need to contribute that amount to the company. They should bring the cash. Here, the company should give. The company should give the cash. Here, the company should give the cash. You may have a doubt that, sir, we are having a cash of 5 lakhs only. Then how you can distribute 5,21,421, 6,429? It is possible. How you know? If they bring the cash of 27,857. Please all of you concentrate. Now, cash available with the liquidator. Cash available with the liquidator. How much? 5 lakhs, no? How much? Yeah, 5 lakhs. Then class C shareholder should bring how much? 27,857. Then the total cash available was 5,27,857. From which class A shareholders will get 5,21,429. Class B shareholders will get 6,429. Sir, now this entire method is known as method A, simply for understanding purpose. In method A, what you should need to do, you should need to find the deficit, which is the difference between the paid up value of the entire equity shareholders and cash available with the liquidator. That deficit you should need to distribute in the face value. Then after distribution of the deficit, the class for which the amount will be negative, we should need to bring the cash, or we should need to introduce such cash into the company. And the classes for which it is positive, then the company should need to distribute. But which is not in logical mode. Sir, why you done like this? Why you did like this? You are having so many questions. But if I'm explaining the same issue under a different method, which is a logical method, then your mind perception will be in different direction. The clear logic might be present there. Okay. But I think so I'm running out of time. I know, which is suspense mode, guys. In the next class, I will reveal the method number B. Till the time, just you can revise the content, what I have explained in today's session. Hope you are enjoyed my session, guys. With respect to liquidation of companies, we'll meet in tomorrow's session itself. Until bye, have a nice day.